This is Senate Public Health, where there is supposed to be a hearing regarding the bill to
Members, we're back in session.
promote life.
We're back in session. At this time, Senator Rapert,
Rapert is going to
if
present.
you would identify yourself.
Senator Jason Rapert.
And go ahead and present your bill, sir.
Thank you, Mr. Chair. Members, thank you for your time, and thank you for giving time for me and Senator Caldwell to get back up here. We were in House Insurance and Commerce. I do want to draw your attention that I think the chairman has allowed for a distribution of a piece. And Senator Caldwell, this is actually one of your constituents, Millie Lace, and she actually was at the UN dealing with some information regarding pro-life issues, and unable to be here personally today. But she has got information there that I think will be of importance to you as you deal with this issue. And with that, unless you have anything else, Mr. Chairman, I'm ready to begin.
If you will, sir, continue.
Well, I want to, first of all, you've seen the bill, had a chance to read the bill over several days, and I thank you for the input that I've received. I will state to you just one thing. It's a small technical thing, but at the back of the bill on the last page, we did adopt an amendment, which actually was adopted on the floor. And so what it states there is this act becomes effective on and after the certification of the Attorney General that the United States Supreme Court overrules in whole or in part the central holding of Roe v. Wade, reaffirmed by Planned Parenthood of Southeastern Pennsylvania versus Casey, thereby restoring to the state of Arkansas the authority to prohibit abortion. And that's the part. It added a small reference there to the Roe and the Casey case. And it's a technical thing, but they wanted to be there, and that was upon discussion with the Attorney General. I want to give you an overview of what SB 149 does, and thank you for making the time today. Arkansas has a long history of legislation and a constitutional amendment even that advocates the protection of unborn human babies. The only thing that has prevented Arkansas from banning abortions altogether is the Roe v. Wade decision of 1973 and related decisions, which is often cited by federal courts when they strike down pro-life legislation around the country. Legal scholars now believe that with new judges being added to the U.S. Supreme Court, there is a very good chance that Roe v. Wade will soon be overturned and the authority of states to regulate and prohibit abortion in their own states will be restored. SB 149 is what has been termed a trigger law, meaning that when and if Roe v. Wade is overturned and the authority to regulate abortion is restored to the individual states, or a U.S. constitutional amendment were to be passed doing the same, that Arkansas would immediately prohibit abortion in our state except when necessary to save the life of a mother in a medical emergency. That exception is the standard of national right to life, and that's why that exception is in the bill. You'll see, if you want to draw your attention to the findings, upon discussion with some of the legal scholars, especially many of the scholars that have been a part of what you have seen out publicly called the moral outcry. The moral outcry is a petition-driven movement actually applying to the Supreme Court itself. And this is part of why I've got the findings here in the bill. And it's to illustrate that there's a grave injustice that's going on that is actually ignoring the most fundamental civil right that any of us have, which is the right to life. Over 60 million little babies in our country have been precluded from that simple, but yet the most humane right that we have, simply to be born. And what happened is over time is the U.S. Supreme Court has actually made decisions that overturned some prior precedent when they realized there was a grave injustice. I bring your attention, it starts there on page 2 of your bill.